Everything you see in this movie is based on data that you can find on CoinMarketCap. Additionally, if you would like to see more updates about XRP and other cryptocurrencies, please consider subscribing to my channel. Let's look at this now. The long-running crypto litigation was settled by the USSLC. According to the SEC, a settlement has been struck with the US government over a lawsuit that had demanded that the securities regulator provide documents pertaining to purported conflicts of interest in its judgments concerning the regulation of cryptocurrencies. A legal battle had broken out between Empower Oversight and the U.S. Securities and Exchange Commission, and the head of the organization provided reasons for why the group had decided to settle the case. The U.S. Securities and Exchange Commission and Empower Oversight reportedly settled their protracted court battle last week, according to Law 300. Since the SEC and the government watchdog had a disagreement over how the regulator should enforce regulations pertaining to Bitcoin companies, this caused market confusion as to whether or not the two had settled the dispute. The president of Empower Oversight, Tristan Leavitt, stated in an article published on it that the organization will continue to battle for answers from the SEC. Upon reviewing all of the documents, he concluded that the sole case that had been settled was the one brought against the SEC in May of 2023. Following the revelation of those records, Power began settlement talks with the Securities and Exchange Commission, while other lawsuits are currently ongoing in court. However, until we just reached a settlement about attorney costs, these debates persisted. The government watchdog has made this statement. At the SEC XRP settlement proceedings, Ripple's chief legal officer, Edward Alder Brody, alludes to accusations. 2 requests are still pending. While the prior requests sought conversations between specific individuals, the present one focuses on data that is of interest to the general public, such as looking for relevant keywords. This is in contrast to 2 pending complaints with the SEC that Empower Oversight is still pursuing in light of the new issues revealed in the SEC's records. Second, in the continuing legal dispute between Ripple and the U.S. Securities and Exchange Commission, Empower Oversight is seeking records relating to the SEC's handling of the company's litigation, a referral regarding the handling of Hyman's conflicts to the SEC, and the initial lawsuit involving litigation brought by former SEC officials. A remark made by XSC Commissioner John Reed Stark about the secondary market sale of XRP has caused quite a stir. Notably, lecturer and attorney Bill Morgan wasted little time in denying Stark's claim, which prompted more debate in the Bitcoin community. At the same time, investors are still worried about vague regulations, and the future of cryptocurrencies is heavily dependent on the nuances of judicial decisions. An XRP attorney disputes the executive's statement. According to Coin Media, a former member of the Securities and Exchange Commission named John Reed Stark recently made a comment that Ripple's attorney Bill Morgan has denied, adding fuel to the fire of the continuing legal battle between Ripple and the SEC. Pro argued that XRP secondary transactions could not be considered investment contracts due to Judge Torres' decision. Bill Morgan, the XRP attorney, disagrees with Stark and says his interpretation is wrong. At the same time, Morgan clarified in a social media post that Judge Torres did not reach any definitive conclusions about the secondary market for XRP. On the contrary, the court explicitly said that it was not giving due consideration to this subject when it was brought before it. On top of that, he has released a court record that supports his claims. Notably, the court's ruling emphasized that in determining whether XRP transactions are investment contracts, the specific facts and circumstances of each transaction are considered. Bill Morgan X is the go-to guy for XR sales on the secondary market. Intermittently, many in the cryptocurrency sector have taken notice of Morgan's remark, which he made in reaction to Stark's claim that Judge Torres' reasoning in the Ripple case is flawed. In order to set the scene, John Reed Stark stated in an X post that according to Judge Torres' ruling, secondary transactions cannot be deemed investment contracts if purchasers are unaware of the seller's identity. In this case, Garlinghouse could be interested. Throughout the day, we were in New York City for the scheduled conference. We also shared a screenshot of a document that was prepared during the time when the court rejected the SEC's move for an interlocutory appeal against Ripple. Everyone involved in the Ripple versus SEC case has agreed, as stated in this paper, to attend the last pretrial conference on April 16, 2024, the date of the next hearing. Conversely, second meeting was to be held before the final pretrial session, but no date was specified for it. The 3-year-long XRP case required all parties' attorneys and the parties themselves to meet for at least 1 hour before the final pretrial conference to discuss potential settlement terms, according to the document dated October 3, 2023. However, this information does support the idea that Ripple's CEO and chief legal officer might have been in New York for the settlement meeting. Regarding the meeting, no official announcements have been made. A $2 billion settlement penalty is being sought by the SEC judge, and Elisa has been attempting to persuade the Securities and Exchange Commission to make a final ruling on the XRP litigation. As part of this decision, the federal agency is asking the court to punish the Bitcoin payment network more than $2 billion for breaking securities laws. Since they are irrelevant to the ongoing XRP litigation, disgorgement, prejudgment, interest, and perpetual injunctions are omitted. Drady spoke out against the $2 billion penalties, claiming that the SEC is engaging in misleading practices by trading in inaccurate, mischaracterized, and intentionally misleading information. Despite this, he did point out a few inconsistencies that the U.S. Securities and Exchange Commission displays. As promised, Darady will respond on Ripple's behalf in April. Uncertainty surrounding the XRP lawsuit has taken on a new dimension, with this likely meaning the sales operations that Ripple is running should be closely monitored by investors. Ripple is scheduled to release 1 billion XRP tokens on April 1st, with a value of $600 according to the calendars. As part of Ripple's monthly sales procedure, this event will be presented to investors. It can have an adverse effect on the XR price in the coming weeks. This is so despite the fact that numerous groups, such as John Denton's Crypto Law, are working to confirm the veracity of this data. Trading advice should not be construed from the data that has been supplied. Any investments made relying on the information presented on this page are not liable for any reason. It is highly recommended that you consult an informed expert and do your own research before making any investing decisions. Panos Mekris, a well-known crypto author, has stated that the success or failure of Ripple's XRP-based cross-border payment solution will not necessarily affect the price of XRP. According to Mekris, Ripple's ODL is designed to not be affected by demand. He emphasized that there is no intrinsic demand for XRP emanating from ODL, and that most ODL transactions comprise the immediate purchase and sale of XRP. Specifically, a document prepared by Ripple for the SEC lends credence to this claim. Most ODL transactions are demand neutral, according to the payment firm statement in the paper, meaning they have no impact on the price of XRP. In addition, Mekris stressed that Ripple's payment system had negative demand. He pointed out that Ripple's escrow is the primary source for the majority of the XRP used for ODL because it introduces new XRP tokens to the market. He thinks the influx of XRP increases selling pressure. Mekris stressed that XRP pricing cannot be increased solely by Ripple's payment mechanism for international transactions.